got the honour and privilege of being joined by William Clegg QC. William is a defence lawyer specialising in serious crime. During his career, he's worked on many high-profile cases, including the shooting of Jill Dando and the Hillsborough disaster. He's also defended more murder cases than any other English barrister currently practising law, that number being in excess of 100. Bill, it's an absolute pleasure to have you with us, and a very warm welcome to you. Our audience this evening comprises, alumni, our friends and partners from the profession, as well as our current students and staff, and we've got quite the turnout, I see. I've had quite a few questions submitted in advance. I'm going to try my best to cover them all. But I suppose to start us off, if we can go back to the beginning, and I can ask you, what inspired you to study law?
I think probably it was watching Perry Mason on television, not the current series, but the old one with Raymond Burr. He never seemed to lose a case, which I thought was very encouraging for a defence lawyer. And I just thought to be paid money to do a job like that seemed too good an opportunity to turn down.
And many of our audience, Bill, this evening are aspiring barristers. So I think what would be nice if you could share what your early years of practice looked like and how you perhaps secured your first job or your first break.
Well, things were very different when I started. There were no such things as pupillage committees and pupillage interviews in order to get started in the profession. It was all very informal. So my experiences really can't be transposed to today very easily. But I think the sort of message that I would give is that if you really want to do this job and really think it's the one job that you want to do more than anything else, don't be put off by what anyone says about it, because it is the most fantastic profession. I've enjoyed it from the day I started till the day I finished. It's challenging, it's enormously rewarding, and I think it's the best job in the world. But you've got to want to do it. There's no point becoming a barrister because you can't think of anything else to do. You've got to be driven to do it and determined to succeed. And if you are, there are enormous rewards in job satisfaction and reasonable rewards in the monetary field available for people who succeed.
And you were talking, I suppose, Bill, about how the profession perhaps has changed a lot since obviously you went into it. What's, I suppose, are the significant changes that you've noticed from obviously when you started out as a junior barrister to obviously the kind of point of your career you are at now?
Well, the big change at the beginning is when I started, pupillage was entirely unregulated. In order to...
It's working.
I'm sorry, can you hear me?
We've got some interference, I think. Can I just ask, I'll just mute. I think one of the audience members has perhaps had a microphone on. Sorry, Bill, please continue.
So the big change is that when I started, pupillage was completely unregulated. Any barrister of 5 years' call could take 2 pupils. They would charge them 100 guineas, that's £105 for the privilege, and there was no method of judging the quality of the pupillage that people received, and no certification at the end to ensure that the people who had done pupillage had been adequately trained at all. It was really a terribly arcane system. Now, as I suspect nearly everybody knows, it's very well regulated with pupillage interviews, grants for pupils, and a proper assessment carried out throughout pupillage to ensure that when people do finish, that they are ready and able to enter the profession properly. So that's a huge change. The other change, I think, really is in the role of chambers and the way that we conduct our profession has changed beyond recognition, as has life, really, over 48 years. I mean, when I started, it is no exaggeration to say they were still using pen and ink to write out all the ledgers in chambers. The diary was written in pencil so that an injured rubber could be used to change a commitment if necessary. There were, of course, no computers, no mobile phones, no electronic diaries or anything like that, no emails. So all these technological advances have altered, I suspect, every profession, but ours perhaps more than most. Papers now come to most barristers electronically. So the old days of a brief tied with red ribbon is, I'm afraid, a thing of the past.
And in all your career, you've undoubtedly recruited and mentored many barristers that have obviously joined the profession and have developed within your own chambers. What characteristics really stand out to you as the kind of characteristics that are the mix, I suppose, to success in what is undoubtedly a challenging profession?
That's a difficult question, really. It's a little bit like an elephant. You know it when you see it, but it's not so easy to describe. I think what we look for more than anything else is certainly commitment and passion for the job, the ability to relate to people. It's very, very important. You've got to be able to converse with somebody about matters that are often some of the most important decisions in their life within perhaps only an hour or two of meeting them. So you've got to be able to win people's confidence, and you've got to be confident without being arrogant, and a good advocate. And I think you recognize it when you see it. That's not much help to much of your audience, I appreciate. I think really, if I could sum it up in this way, you've got to convey your own passion and enthusiasm for the job to the people that interview you and meet you. And if you do that, then you'll be halfway to getting your pupillage or tenancy or your start in the profession. And many of those joining us this evening, I know some of my students in Leeds included, will be really, I suppose, interested in a career at the criminal bar, which has had some bad press in recent years. And I suppose what I'd like to know, Bill, is would you still encourage those students to pursue a career at the criminal bar? And perhaps what advice would you give them specifically into that route? Well, repeating what I said earlier, I would certainly encourage anybody to go into the criminal law if that is the area of law where your enthusiasm and your drive wants to take you. It's a fantastic job being a criminal advocate. I've enjoyed every minute of it. The remuneration you get from the public purse for doing publicly funded work is lower than it was. It's still possible to lead a perfectly good life, as it were, and survive on it, but it's not going to get you very wealthy. The advice that I always give people when they're starting out in my chambers is, by all means, focus on your criminal practice and build it up, but try to develop some area of expertise that will allow you to supplement your income by doing some private work in a different field that is adjacent to crime, which would be typically either regulatory work, extradition, administrative law, something like that you can develop that you like. You can get a foothold in that, and you will find that is also rewarding and almost certainly more remunerative. But there are many ways in which chambers will help people starting out in crime. It's quite common to do some well-paid secondments in the early years of practice that will help supplement your income, either for government departments or more normally for large firms of solicitors that are perhaps doing an enormous case and need help. And they can be opportunities to build up contacts that you can keep really throughout your career. So I'm not full of gloom and doom about the criminal bar, far from it. It is still, I think, the best job that you can possibly have.
I think that's very, very encouraging to hear. And I suppose thinking about your career and the cases that you've worked on, is there a case or a particularly a number of cases that you've worked on that have perhaps had the kind of biggest impact on you whilst you've been practicing?
Depends slightly what you mean by the word impact, but I think the cases that I've found that have been in a way the most challenging and at the same time the most interesting have been international war crimes. Margaret Thatcher, towards the end of her premiership, passed the War Crimes Act that allowed the prosecution of war criminals from the Second World War to be prosecuted in this country for the first time. And I defended the only two people ever to be prosecuted under that act, Simeon Serafinovich and Antony Sawoniuk. And they were cases that were involving alleged criminality that took place in 1942, 1943 in Belarus. So there was enormous challenge there in seeking to prepare that case for trial that involved a number of trips to Belarus, the interviewing of witnesses, and in one occasion, the taking of evidence in Belarus in an elderly lady's house, and the examination of documents that hadn't really been looked at since the end of the Second World War. So I think that was a particularly challenging case. And of course, dealing with the awfulness of the Holocaust so closely was quite a sobering experience. And that led me on to do war crimes work at the International Court in The Hague for the former Yugoslavia, where I defended in a number of the first appeal cases there, starting with Tadic, which was also quite a challenging series of cases. So I think they were probably the most challenging, but each case brings its own problems.
Undoubtedly. And during your career, you've defended some heinous crimes. And I suppose one of the questions that's come from the audience members this evening is, how do you mentally and emotionally cope with the subject matter of those cases and the things that you're resultantly exposed to as a advocate for, obviously, the accused?
I think it's something that is inbred into you really early on in the job. You couldn't do it if you allowed yourself to get emotionally involved in every case. You'd be an emotional wreck in no time. You have to try to be one step removed from the case. I mean, in the same way, you could say, how can a surgeon live with himself when he spends all day sticking a knife into somebody? He's doing a job and I'm doing a job. And all I'm doing really is being the mouthpiece for people who are accused of crime, who haven't got the ability to speak for themselves. So I think you train yourself not to get too involved in the emotions of a case. And I think that's something that comes to barristers quite normally. You couldn't do the job otherwise.
And conversely, there's a question come in here. What advice would you give to prosecutors then?
Well, I've only done a little bit of prosecuting over the years. My clerk said it was like the Olympic Games. It happened once every 4 years. So I wouldn't pretend to be an experienced prosecutor, but I think there are different skills. And I've been against, I would say, probably the best prosecutors that this country has produced in the last 20 or 30 years. I think the secret of a really good prosecutor is not to try to get involved too much in the emotions of the case, and to try to be as detached as they can be, remembering that his job is not actually to obtain a conviction, but to lay the evidence before the court for the court to decide if the case is proved. And I think there is a danger in recent years that prosecutors have come to look upon their job as a job to get a conviction. And it's not their job to get a conviction. It's their job to place the evidence, all the evidence, before the court. Sometimes evidence that doesn't help their case. So I think detachment is probably the one thing that makes a great prosecutor, and of course, the normal skills of the job, cross-examination, and mastery of the brief.
And some of the cases that you've worked on, Bill, I mean, they've had huge media attention. How do you compensate when a case has effectively already been tried by the media?
Well, I think you can use it to your advantage.
Bill, we've lost you. It might be just worth testing whether we can take the video off at this point, if we can resume sound.
They've all the case in the papers, think that they of course.
Bill, can you hear me now?
I can hear you. Can you hear me?
Yeah, so we lost your answer to that question. So if you wouldn't mind, if you could just start from where you began.
Right. Remind me of the question, sorry.
Yeah, of course, I should have done that. So my question was, you've worked on a lot of cases that have had huge media attention. And it was really, how do you compensate as a defence attorney when the case has effectively been tried by the media?
Well, I think you can turn it to your advantage. You could say to a jury, they've all read the papers. All the papers think they know the answer to this case. They all know who did the crime. They all say the defendant's guilty. There's only one thing that all the papers have in common and all the journalists have in common. None of them have heard one word of the evidence in this case. And jurors are very anxious to try and get the right answer. And they really will focus on the evidence and try to do the job that they've sworn to do, and get the right result. I haven't found really that publicity is something that's been a huge problem, although other people take a different view. I mean, I've done quite a lot of cases where the publicity has been very adverse to the defendant. I mean, I think of someone like Barry George in the Jill Dando case. Didn't stop the jury finding him not guilty.
And there's a question coming from the audience. I think this is a particularly interesting one. They've asked you, Bill, if you had to pick a piece of legislation or case law to change, from your experience advocating, what would it be, and how do you think it would affect cases going forward?
Gosh. I think the one thing I would change would be the automatic life sentence for murder. Under the current law, everybody who is convicted of murder or who pleads guilty to murder is sentenced to life imprisonment. In many ways, it's a fiction. Only at the tiniest fraction, less than 1%, stay in prison for the rest of their life. Most of them are released in about 15, 18, maybe 20 years. The problem with having a fixed sentence like that is that there's no incentive for somebody to plead guilty, even when the evidence is overwhelming, because they're going to get life sentence anyway. They can't see any advantage in pleading. As a result, there are very few pleas of guilty in murder cases. I think it would be much better if the judge had a discretion, and indeed that the charging had a discretion. So you have sort of first-degree murder, second-degree murder, third-degree murder. You could keep automatic life sentence for the most serious of murders, but so many of them are really of a domestic nature that nobody thinks warrants putting somebody in prison for the rest of their life, where, I just take as an example, perhaps a single mother is living in a one-bedroom flat and in very difficult circumstances eventually snaps and tragically kills her child. Few people would think that that woman should be locked up for the rest of her life. Obviously, there needs to be punishment. But I think if a judge was allowed to have some discretion and pass a determinate sentence, then a lot of people like that would plead guilty, whereas otherwise now they put forward really quite often pretty hopeless defences and occupy a great deal of court time as a result.
That was really interesting. I have another question here, which is, do you think the criminal bar can withstand the challenges it faces, and particularly those challenges being lack of funding, the growing backlog of cases in both the Crown and Magistrates Court, and court closures, and the low pay for junior legal aid barristers?
Well, the short answer is it's going to have to, because no country can survive without a functioning criminal justice system. So we are going to have and must have a criminal justice system that does function. Backlogs, of course, at the moment are particularly long because of COVID. And I know that they're desperate to try to open up some temporary courts. And they're calling them Nightingale courts. Not terribly original, but that doesn't matter. In order to try to get the backlog down. But I do think that funding is a problem. One interesting feature that I've found, having written the book I did, was I went to quite a lot of literary festivals before COVID. And speaking to the public, I would say in nearly every venue that I spoke, I was asked a question by the public about the underfunding of legal aid. And it was quite obvious to me that the public that I could see who came to those talks really appreciated the need to have the law properly financed. And I know the current Lord Chancellor is pushing for a bigger budget. But it's not easy. I mean, particularly now the country's borrowed so much money, who knows when it'll ever get paid back. So it's not going to be easy to get more funding. But I think the criminal bar will survive, and it will adapt, as it has already adapted to changing circumstances. One thing that's happened is there's a great deal more privately funded criminal defence now than there used to be, because legal aid is so difficult to come by, which is not such a bad thing for the young barrister starting out.
And how can young barristers, I suppose, help the position here? I mean, are there pro bono schemes or things that they can get involved in that actually would have, I suppose, an impact in improving this?
Well, I think the main thing for the young barristers is to support the profession's trade union, the Criminal Bar Association. They are extremely active in pushing for proper pay and proper conditions for barristers. I mean, they have a lot of support from judges as well. I mean, people mustn't think that judges are somehow acting against barristers or think that they shouldn't be paid properly. Most judges were barristers. The few that weren't were probably solicitors or academics. They know what what the pressures of the profession are like, and they support the bar being properly funded. Various things are happening with the increase of listings, electronic hearings, when people can do it from chambers in relation to a lot of applications that would previously be done in open court. That makes things a lot easier for the advocate, and judges do try to help insofar as they can. So I think the best thing that the young barrister can do is to join the Criminal Bar Association, join one of the legal charities like Justice, and help through that. And of course, write your MP.
And you obviously mentioned, I think, some of the technologies that obviously are being deployed in the profession now, but do you, I suppose, recognise any benefits from COVID-19 and how that might improve the legal profession as a whole, or anything that could be adopted and retained going forward?
Well, I think the one big advantage from COVID has been the use of remote hearings, where the barristers don't have to go to court. And that is something we've been pushing for years, and some courts and some judges have been resistant to it. But of course, now it's an absolute necessity. And that, I think, is a real bonus.
And Bill, you spoke earlier about, I suppose, junior barristers and the kind of advice that you gave to find a specialism as well within that criminal practice. How easy is it for a barrister to change between specialisms? So once you actually start out in your career and you have a couple of years and a practice under your belt, how easy is it to either, I suppose, extend that practice or to actually diversify what you're doing entirely?
It depends really where you are. When I started, a lot of chambers would cover the whole gamut of legal work. And there'd be people in chambers doing family law, people doing civil law, people doing chancery, people doing crime. And it was then quite easy to move from one specialism to another. That's become much more difficult now because chambers are very specialised. My chambers at 2 Bedford Road is primarily criminal set. We do licensing, we do extradition, we do a lot of regulatory work, public inquiries, that sort of thing, but they're all what I would call quasi-crime. It would be almost impossible from my chamber interference at the moment, when someone's got their mic on.
Yes,
it would be very difficult to move from my chambers to chancery practice, for example, and vice versa.
And I suppose so the advice you give to those in the audience this evening then is to really, I suppose, commit to what they want to do and then look for specialisms that sort of derive from that core practice.
Yes, definitely. I mean, every criminal set of chambers, for example, will have solicitors who get involved with extradition, admin law, because they're often a knock-on from criminal cases and criminal clients. So that sort of specialism is always open to people in the criminal set, certainly regulatory law. And that's, I think, what you want to focus on. But what the message is really that the chambers you start out in, that speciality is really going to be something you want to do and you're going to be prepared to stick out, because it's not easy to move. There's no point starting out in a criminal set if you want to become a family barrister, or vice versa.
And you personally, what would be in your second preferred route if you could rewind the clock? Would there been any other avenue you'd have explored other than defence?
I don't think so, to be honest. I mean, it was all I ever wanted to do, and I've just loved doing it. So I don't really think that I was ever very attracted to anything else. I did when I started. I used to do a reasonable amount of divorce, which before 1976 was quite a profitable area of the law for barristers, because every divorce had to be heard in court. There was no question of it being done on paper, as has happened since. And therefore, there was to put it bluntly, quite a lot of very easy money to be made doing divorce work. And I did that for some years and then moved over. But that was because my chambers did both types of work and it was easy to do. But I don't think I enjoyed it. And I couldn't bear all the arguing about money and kids and who took the boy to scouts and this sort of thing. It drove me mad.
And I suppose thinking a little bit about really who's inspired you during your career, and perhaps some of the people you've worked with have been particularly impressive. Are you able to share anything on that, Bill?
Yes, I mean, when I started out, the profession was much smaller than it is now. I mean, there was something like 15% of the Crown Courts there are now in London then operating. I mean, huge court centres like Snaresbrook and Wood Green and Isleworth and Luton just didn't exist. So the number of senior barristers was much smaller than now. So I looked up to them rather like gods in a way. The great advocates of my youth, people like John Matthew and Robin Simpson and John Marriage. And they were certainly people that I would aspire to. And what I did, and I would encourage all people starting out, I would go into court and watch them and just try and pick up some hints of advocacy from having seen it in court. And I don't think that's anything that you should stop doing. You can always learn more in this job.
And how about the judges that you've appeared before? Is there any particular judge that stands out or that you've learned from?
Well, there depends. There are two possibilities there, aren't there? There's certainly some very great judges I've appeared in front of. Tom Bingham, Lord Chief Justice, and then the senior law lord was, I think most people will recognise as the outstanding judge of his generation, perhaps the most outstanding judge since the Second World War. He was astonishing to appear in front of, courteous but with a razor-sharp mind, and a very liberal and humane man. He was one of the greatest judges I've ever appeared in front of. Baroness Hale, another I've appeared in front of. These are people that you can sort of admire from a distance, but secretly know you could never emulate. There have, of course, been some terrible judges, and you can learn from them as well. Judges, not so many now as there used to be, who were biased against the defence, prejudiced, rude, bullying, and you don't forget those either. But they really are now very much something of the past. Judges are trained, if that's the right word. I get trained when I sit as a judge, and I think by and large they tend to be rather user-friendly these days.
And I think that brings us nicely to one of the questions that's come from the audience, which is there's a trend for female defence barristers to be allocated predominantly sex offence crimes. And do you believe that the gender of the advocate can positively or negatively influence the verdict of a trial?
No, I don't. And I think that was something that was certainly spoken about a lot 10, 15, 20 years ago. But I haven't heard it said so much these days, to be honest. And I don't think it is nearly as common as it perhaps used to be. There was a feeling amongst defendants that if they had a woman defending them, then somehow that would make their defence more credible. I think it was complete nonsense, and I don't really think many people think that anymore.
And I suppose another question, this time I think obviously linked to our judicial process, but what are your thoughts on televising court proceedings?
Well, look, the Supreme Court is, of course, televised, and we all watched the prorogation case, or part of it, I suspect. That, I think, goes out on a sort of permanent feed. The Court of Appeal does record some cases, primarily quite short sentence appeals. They don't seem to get put onto mainstream television very much. So far as trials themselves, I think there are problems with filming them that are not necessarily insuperable. I think most people agree that the jury should not be seen on television and be capable of being identified. I think they're entitled to a degree of anonymity, and it would also be a potential risk for anybody who is anxious to try to influence the outcome of a case to have ready access to what a juror looked like. So I think they should be anonymized. But I've certainly appeared in court where there's been live television myself. All the proceedings in The Hague, which I appeared in front of, were broadcast live to a channel in Holland and also a channel in the former Yugoslavia. And they were, proceedings were translated into 3 languages, English, French, and Serbo-Croat. So I don't think it made any difference to the advocacy that we had there that it was actually being broadcast. And certainly in one of the appeals we had evidence, and I don't think anybody reacted or behaved any differently because you were on television. And of course, in public inquiries, they're televised as well. When I've done those, they've been televised. And again, I don't think there's been any problem. So in principle, I don't see a difficulty with it as long as you get over the logistics of it. The trouble is, proceedings are quite long. I mean, you have a trial. I'm just thinking of some of the trials I've done. I mean, you think of the Jill Dando case, it lasted for about 6 weeks. It's going to be difficult to hold an audience for that long on television. They want it over in 3 one-hour episodes. And then your problem is editing it. You can distort the evidence because the people watching will only see the bit you publish. So I think there are problems, but in principle, we believe in open justice and people should be allowed to see it.
Thanks, Bill. And a question actually that links back to the question I previously asked you about what piece of law or legislation you'd change, and you were talking about relaxing the sentence for murder from a life sentence. The question is, how would you respond to those that say the law on crime is already too soft, and whether you share that opinion?
Well, I don't share the opinion. Sentences are much longer than they were 30 or 40 years ago, much longer. And I think in many cases, too long. We have too many people in prison who shouldn't be there. Many of them are inadequate. Many of them have alcohol and drug problems that are much better treated outside the prison environment. There's a sense that some people get sent to prison because the courts just get fed up of seeing them and can think of nothing else to do with them, have exhausted other remedies. So I think we have far too many people in prison, and some of them for far too long. I mean, obviously, there's a hardcore of rapists, professional criminals, murderers who need to be kept in prison for a long time. No one's suggesting that shouldn't be the case. But it's one area of law that I think we've really got wrong is causing motor manslaughter, causing death by dangerous driving. Now, when I started, the maximum penalty for that offence was 5 years. It's now 15 years, and there's a proposal to make it life imprisonment. Now, that is an offence which the ordinary sentence has increased, probably at least doubled in the time that I've been at the bar. And very often, these are sad cases for both the defendant and as well as the victim. I mean, I still think of a case that I did many years ago for a lorry driver who fell asleep at the wheel. Obviously, he didn't intend to. It was a serious lapse in what was otherwise a very good motoring record, and he tragically killed somebody. Now, the result for him was, if my memory is right, he went to prison for 30 months. He lost his home because the mortgage couldn't be paid in his absence, so that was repossessed. His wife left him, he lost his family. He obviously lost his job. He couldn't work when he came out because he was banned from driving. And it ruined his life completely. Now, I'm not saying he didn't deserve to be punished, but I think to increase the sentences from what was passed then, that was a case heard 20 years ago, now he'd probably get 5 years in prison, which I think is way beyond what it ought to be for a crime that has actually no moral culpability, in the sense that he hasn't intended to do anybody any harm.
And I think another question that's relevant here that's come in is, when you're defending high-profile cases, how did you manage the sometimes difficult opinions of defence counsel from the press and the public?
How did I do what to defend to my... Sorry, I didn't catch the last bit of the question.
I think the signal's somewhat broken up. So when defending high-profile cases, how did you manage to sometimes the sometimes difficult opinions of defence counsel from the press and the public?
I never had much of a problem with journalists when I was defending high-profile cases. I mean, it's quite a small world, and we all get to know each other over the years. And surprisingly, you soon know who you can trust and who you can't trust. I never had any difficulty in talking off the record and on the record to journalists. And I can only think of one occasion where a confidence was broken. So I don't really think it is a problem.
And a question here, what was the most outlandish defence a client has ever run or tried to run?
Well, that's a... let me think. That has got me stumped for a moment. Let me just think. Well, I did defend a man once for murder, and it was in many ways a tragic case. He was clearly mentally unstable, and an American tourist who was staying at the Cumberland Hotel in London went for a walk before going to bed. And walking around the block, this man came out of a shop front and stabbed him to death. It was a very sad case, and he was clearly mentally disturbed. By the time I got the brief, he'd sacked about 4 barristers, and they were desperate to have the case heard. So I agreed to take it on. And the evidence was that he was found by the police around the corner from the dead man, holding the knife that killed him, which was covered in blood, and he himself was covered in the blood of the deceased. He was saying that he was pleading not guilty, and his instructions were that he had nothing to do with the murder at all and has no explanation at all for the knife being in his hand. And I remember saying to him, we've got a very tricky prosecutor in this case. It was a friend of mine called John Nutting. And I've got a feeling that he might ask you what you were doing with a blood-stained knife just around the corner from the dead man about 15 minutes after he was killed. To which the defendant said to me, if he asks that question, I'll tell him to mind his own business. And true to form, we did ask the question, and true to form, the client did tell him to mind his own business. Oddly enough, the jury took quite a long time to convict him, but convict him they did. So I think it was probably the most hopeless case I've ever had to defend it.
That's a really great anecdote. Thank you very much for sharing that. I suppose moving on to a different area, you've not, I suppose, long ago published a book, Bill, and I thought it'd be interesting to share with the audience what inspired you to actually write that. You've obviously had a fantastic career, and to have obviously put it down on paper must have been somewhat of a challenge. But I suppose what prompted you to start that process?
Well, I think the process began by my reading a book by a man called Henry Marsh, who was a neurosurgeon. And it became a very popular book. It was in the bestsellers list. And what he did was to describe neurosurgery for the layman. And I found it a fascinating book and a great challenge. And when I was approached about possibly writing a book, I thought that if I could write something that explained to lay people what it was like to be a barrister, how you became a barrister, how you became a silk, how you became a judge, how you worked, how you did your cases, in a way that was hopefully intelligible to the person who knew nothing about the law, then that could be worthwhile. And that's really what I tried to do. I don't know whether I've succeeded. That was my aim. And the publishers thought that if I was to intersperse that, so that every alternate chapter would be a resume of a case that I'd done, perhaps illustrating some of the examples I'd given in the others, then that would make it a more attractive book to publish. So that's really how it came about, and that was really my motivation. I didn't want to write a standard autobiography, and it's not a standard autobiography.
And for those of you listening, the book's called Under the Wig. Is that right, Bill?
It is indeed. Available, I think, at a reduced rate as a result of signing on for this course.
Yeah, I'd encourage you all to go out and get a coffee.
Yeah.
And the process of actually compiling that book, you did with a ghostwriter?
I did.
How was that experience?
Well, it was a lifeline for me, because having agreed terms with the publisher to write the book, I was then in full-time practice. And I found that I was making very slow progress, to be honest. I mean, it was the last thing I did every day was to pick it up. And often I'd worked pretty long hours. It comes to about 7:30 or 8 at night. And I thought, they now want me to start writing the book. And I'm afraid I only got a paragraph or two before the call for the gin and tonic became irresistible. So after about 2 or 3 months, it was perfectly obvious that it was going to take me years to write it at the rate I was going. So we then had a meeting with the publisher, and I just said, look, this is hopeless. And they came up with the idea of a ghostwriter. And I knew somebody who was a journalist who had experience of that. And we put the deal to him, and he was happy with it. And it was enormously successful. I found it much easier talking about it with him than I did writing it. And he also made me be slightly more disciplined about it, because he would set down times when he would come, and therefore I had no escape.
I think we've got a time for a couple of last questions, and there are a few here. I think aspiring barristers perhaps wanting some tips or steer on the techniques that you've obviously refined during your career, Bill. So there's a question here, which is, was there a particular style that you used during cross-examination, or did it depend on the witness and the particular case?
Well, it certainly depends on the witness and the particular case. You obviously can't cross-examine a supergrass criminal in the same way that you would cross-examine a complainant in a rape case, or a child. So you've obviously got to adapt your cross-examination skills to the witness. And as with all advocacy, what you've primarily got to focus on is what is the impact it's having on the decider of fact in the case, be that magistrate, judge, or jury. So the objective of cross-examination is obviously to destroy the evidence that is against you, or at any rate, to demonstrate why what the witness has said is unreliable. There are a number of ways you can do that, and that depends on the facts of each case. But what you've got to do is to do it in a way that a jury will find it attractive and sympathetic to your client. Over-aggressive cross-examination can be obviously counterproductive. At the other end of the scale, there's no point
We've lost you, Bill. Witness
who is you've got to pitch it for the case, but what you're really trying to do is to get the decider of fact on your side, which is what you need to do really with all advocacy.
And how much do you focus on an individual within the jury?
That varies. Particularly in a long case, you do tend to find that there'll be 3 or 4, perhaps, who are obviously slightly more alert than some of the others, and you like to try and think that you've worked out who's going to be the more persuasive in the retiring room out of the people you see. And of course, you're there with them for many hours, months sometimes. So you do get a fairly good idea about who is the sort of popular person in the jury room, who's the dominant one. You see the little interchanges between them when they're coming in and out of court, and even when they're in court. And you do undoubtedly focus your advocacy, not exclusively, but rather pointedly at some of those who you think will be the people who will be most influential.
It's really very interesting. And another question that we've got here: how do you balance being emotionally detached from a case? And I suppose that's referring back to those heinous crimes that you've obviously defended, but you've also cared about the client's outcome at the same time.
Well, again, I think it's something that comes with experience and the job. I think you can care a lot, but still be emotionally detached. They're different emotions. The surgeon cares a lot about whether his patient lives or dies, but he can still be emotionally detached when he's sticking a knife into his stomach. And I think it's the same for a barrister in a way. I think you can be emotionally detached, but still care very much about the result. We all care about the result.
Thank you very much. I think we've probably got time for just one last question. So I'm just going to have a quick look at. And I think perhaps finishing with what advice would you obviously share with everyone that's joined this evening in terms of, I suppose, navigating their careers in the current climate? So we've got aspiring barristers studying, obviously, with the challenges that COVID places on them. We've got chambers that are deferring pupillage. So people that ordinarily would have actually sought that opportunity and been successful this year, that's not available to them. What advice would you share in terms of persevering with that profession and things perhaps that they could undertake to kind of distinguish themselves from their peers and make sure that when we obviously move into better times, they're the ones that are getting those opportunities?
Well, the first bit of advice is don't give up. If you really want to do this job, persevere and keep at it. The second piece of advice is that if you have to wait a further year for pupillage or you have a year out, then make the most of it to improve your CV. Go and try and get some paralegal work at a good firm of solicitors, or work as a legal researcher for a judge, if you can be taken on to do that. But try to keep in the profession. Don't decide that you're going to take a gap year and go to Thailand for 12 months, or not that you can get there now anyway. But if you can try to improve your CV and come back, it shows commitment to the profession. Now, of the people taken on in my old set, one of those worked for a leading London firm of solicitors for 3 years before coming back, having failed to get pupillage in the first place. And she came back with a lot more experience, a lot more confidence than she had 3 years before, and has now got a pupillage and is doing very, very well. That's an example, really, of what somebody has done, which has worked out well. Other people I know have worked for judges, but try to do something that is law-related and will help your CV. I mean, when we see CVs now, everybody's climbed Kilimanjaro for charity. Everybody's got umpteen other activities and plays the violin to level 12 and runs marathons twice a year. To be honest, they don't really impress very much now, if truth be told. I mean, it is quite unusual now to find somebody who hasn't got a whole string of other activity. I think what people really want is convincing that there is a real commitment to do the job and to do it well. And if you're interested in becoming a barrister, then of course involve yourself in your Inn of Court. Do the mooting, do the debates. There's nothing like putting down on your CV that you won the mooting prize at Gray's Inn for 2020. The one who won it in 2020 has just got a very good pupillage. One of the references he got, I wrote, because I judged the moot, and I was able to say how impressive he was. So keep up any contacts you have, and don't give up.
Bill, thank you very much indeed. I think that's been a really inspiring and interesting hour that we've obviously had with you. And thank you very much for taking the time to obviously have shared all those experiences and anecdotes and thoughts and advice with the attendees this evening. I'll finish here, but thank you to all of you that have made the effort to join this evening. We've had a fantastic turnout, and I think you'll have all had huge benefit from obviously hearing Bill speak and the experiences that he's been able to share with you this evening. For those of you that are studying with us, I look forward to having an opportunity to interact with you going forward. For those of you that have joined us this evening, either having joined as alumni or professionals, I hope you all stay safe and please, continue to engage with us going forward. Thank you on behalf of the University of Law. Thank you, Maria and Leonor, for organising this evening. And thanks again, once again, Bill, for obviously attending and sharing that with us. Good night, everybody.